Welcome back after a short break. We are now on the third panel. The next speaker will be Dr. Marcin Rau, who will present a paper under the title Choosing the Lesser Evil, Pretrial Detention During COVID-19.
Thank you very much. It's a great pleasure to be part of the conference. So, since we have only 10 minutes to discuss this huge topic, I'm going to keep things brief and efficient. So, let's get started and let's move to the first point. Ladies and gentlemen, let's imagine Pruszków, city next to Warsaw, with over 75,000 inhabitants. This city, this is more or less the number of people who are currently in jail and in prison in Poland. For our Hungarian colleagues, I would like to compare this. This is the half of the population of the city of Miskolc. So this is the number of people who are deprived of liberty now in 172 prisons and detention centers in Poland. So, for them, coronavirus might be an even bigger problem than for us, because in both jails and prisons, social distancing is nearly impossible. The risk of infection is high, and the medical care is often dangerously inadequate. So, the individuals accused of crimes before trial, or the prisoners, don't have a free access to immediate specialist medical consultation, because in the condition of isolation is much more difficult than in the conditions of freedom. As a consequence, the diagnosis time of a detainee who is likely to be infected with the COVID-19 is significantly longer, while the time is crucial for the safety for both the detainee and all persons who had directly contact with him. Considering the dynamic space of spreading the virus, at the constant and the same time contact between prisoners and prison service officers, so that threat to their health and life in detention is particularly high. Moreover, in connection with chronic diseases, including diabetes, heart diseases, or neurological disorders, which are common for the prisoners, is only matter of time before it develops a serious and potentially difficult health complication, in which may significantly contribute even to death of the detainee. Those developments present numerous constitutional concerns, from deprivation of the right to legal counsel and speedy trial to violation of deprivation of freedom. But this case is not only common in Poland, because according to the data from the United States, the situation is very similar. If the number of detainees in Poland corresponds to the number of citizens of Pruszków, or the half of the population of Miskolc, the number of people across the United States who are locked up in jails or prisons is bigger than 2 million. So you can imagine it's like whole Warsaw, or even bigger, the whole capital of France, Paris. So can you imagine how big number of people is involved in this problem? Of course, another issue which is especially which I'd like to especially underline, that there is overrepresentation of Black Americans in jail, and moreover, as the data from the United States said, Black Americans experience dramatically higher rates of infection of COVID-19. I will also now give you an example from Texas, because in Texas, it was the sheriffs and the judges began to release low-risk and medically vulnerable prisoners during the pandemic, but the governor of Texas, Mr. Greg Abbott, didn't like it, and he issued an executive order restricted the power to free defendants without a caution, without a bond. So the number of releases dropped significantly, even as COVID-19 begins to spread, spreading through the jails in Dallas, Houston, San Antonio, and other cities. So it's in the view of above, is it possible? The question arises: is it possible to withdraw from pretrial detention in some cases due to the risk of coronavirus infection? The first answer would be absolutely yes. But the devil is in the details. So, ladies and gentlemen, imagine the perpetrator who attempted to murder a neighbor and he was arrested by the police. So, how we can be sure that on the outside he will not fulfill his original intention and kill the victim? Or what about the perpetrator of domestic violence? Should a man who beats, humiliated, and tortured his wife be released from custody in order to return to her, to live with her in the same apartment? Or who can tell us that if the rapist is released, will not rape again? Thus, we come to the key question: what is the lesser evil? On the one hand, we must ensure the rights of crimes victims and prevent them from becoming the victims again. But on the other hand, there's a suspect who shouldn't die in the locked cell by the disease. In both cases, as you can imagine, in both cases, it sounds like a Greek tragedy. Both solutions end in the same way: someone may die. In my mind, pretrial detention should also depend on the criminal past of the perpetrator and the time of crime committed. However, as you can imagine, the answer is not always clear, because there is not black or white. The life is full of shades of gray. Maybe the solution would be to increase of use of granting electronic tagging instead of police supervision. However, if the suspect is not accused or not sentenced, it also would be illegal to deprive his liberty by electronic tagging in any cases. So where would be the correct answer? What should we do? This is exactly the question from my presentation. What is the lesser evil? And to sum up my presentation, let me quote the famous Polish author Andrzej Sapkowski, who is best known as the author of Witcher series. And in one of his books, he wrote, "Only evil and greater evil exists, and beyond them, in the shadow, lurks true evil. True evil is something you can barely imagine, even if you believe nothing can surprise you anymore. And sometimes true evil seizes you by the throat and demands to choose between it and another one, slightly lesser evil." So the role of the judge is not to choose between evil and lesser evil. The role of judge is to choose between true evil and even greater evil. And those is the real Greek tragedy which every judge in the time of pandemic have to find solution for it. Thank you very much for your attention, and thanks again for having me.
Thank you so much, sir. The author of the next paper under the title Deepfake as a New Disinformation Tool on Social Media is Master of Science Eva Płocha. Please start.
Good afternoon, ladies and gentlemen. Thank you for giving me the floor. I'm very grateful for giving me the possibility to present my topic, which is, of course, deepfake as an evidence in criminal proceedings, doubts, problems, and controversies. Ladies and gentlemen, deepfakes are defined as a highly realistic and difficult to detect digital manipulations of audio or video. And there are no doubts that deepfakes, apart from being a new tool for social media misinformation and being used for social engineering purposes, can be used to commit crimes. In principle, any crime can be committed with the direct or indirect use of deepfake. Deepfake technology can be used by anyone to create videos of any person doing any action or saying anything. It is very easy because everyone can have access to applications used to create deepfakes even for free. No wonder that there is more and more discussion about whether the provisions of substantive criminal law, in particular the Criminal Code, properly protect against the creation, use, or dissemination of malicious deepfakes. However, we cannot forget about the criminal procedural aspects of the use of deepfakes. Usually, when we think about the criminal use of deepfakes, we tend to focus on the crime itself, whether it was prepared, attempted, or committed using a deepfake. Meanwhile, deepfake may not have a direct connection with the crime itself, but can be also considered as an evidence for other circumstances affecting the content of the judgment in the criminal trial. For example, it may be evidence of innocence, in particular, that the accused was not at the scene of the crime when it was committed. Anyway, in Polish criminal proceedings, evidence is taken ex officio or at the request of the parties. There is no doubt that it is the opposing party, the public prosecutor or the court that should have doubts about authenticity or credibility of evidence, in particular that it is based on deepfake technology. Such doubts may already be noticeable at first glance, especially when the recording raises obvious doubts. For example, it's hard to believe that a person has behaved in a certain way These are in particular public figures whose views are known to the public. Views and opinions are really well known. It's hard to believe that they could say or do something against their personal opinions and views. Such recordings may appear suspicious. The same goes with recordings of poor quality. But of course, we know that this kind of technology is developing and is getting better and better, and it's much harder to notice the difference between reality and fiction created in deepfakes. In my opinion, in such situations, it is easier to convince the procedural authority to take procedural steps to verify the authenticity and credibility of such evidence. It should be emphasized that it's easier to convince a public prosecutor or a court to take such an action when it comes to evidence that is of central importance in a case. And in other types of situations, it's rather hard to convince them to base on such evidence. It should be also considered whether the Code of Criminal Procedure should include a clear ban on admitting evidence based on deepfake technology. In Article 169, paragraph 1.1 of Polish Code of Criminal Procedure, it is written that a motion for evidence shall be rejected when the taking of such evidence is inadmissible. In my opinion, there is no need to create a new evidence ban because deepfake is just a new tool that can be used to cook evidence. It should be pointed out how important it is to educate judges and prosecutors in the field of recognizing evidence cooked by using deepfakes. We must remember that it is up to the procedural authorities to decide whether to admit evidence or reject it. Sometimes the arguments of the parties may turn out to be insufficient. That is why the education of participants in criminal proceedings is so important. Judges and prosecutors must be sensitized to this, must be aware to this phenomenon and be aware of its mechanisms. Only a proper preparation will allow to avoid the situation of unjustified dismissal, rejection of an evidence application aimed at proving that the evidence is a deepfake. In case of any doubts as to the authenticity or credibility of evidence, the procedural authority should appoint an expert, a witness expert in the field of computer forensics, who would determine whether the evidence is a deepfake. Only after obtaining an witness expert opinion, the court is able to state whether the evidence is authentic or and credible or not. In conclusion, it should be pointed out that in the procedural aspect, it is not so necessary to amend the provisions of the Code of Criminal Procedure. The most important part is education of all participants of the criminal process, in particular judges and prosecutors, because they decide about the direction of investigation and later trial. Thank you for your attention.
Thank you very much. Now the floor will be taken by Dr. Grzegorz Ocieczek.
Good morning, ladies and gentlemen. First of all, I would like to thanks for invitation. My name is Grzegorz Ocieczek, and I am currently an assistant professor at the Faculty of Law Administration of the University of Cardinal Stefan Wyszyński in Warsaw, and an advisor to the National Prosecutor. For many years, I worked as an active prosecutor in the organized crime department of the prosecutor's office. This is where my interest in the issue of the institution of crown witness stems from, the more so because it raises numerous controversies both among representatives of law enforcement agencies and the judiciary in our country. Since 2012, I have been conducting empirical research related to the institution of crown witness, both from a substantive and criminal procedural point of view. Currently, I would like to share with you partial results of my research, which I conducted at the turn of 2019 and 2020. This research concerned the institution of crown witness in the penal procedure sense, commonly referred to as a large crown witness. The research in question took the form of so-called expert interviews. At the same time, it was qualitative, non-standardized research aimed at proceeding specialized information obtained from persons with high knowledge of the field under examination, and then comparing it with the results of research conducted by crown witnesses themselves and other persons, including prosecutors and representatives of other law enforcement bodies. The main research problem with the use of conducted interviews was to establish whether the institution of crown witness currently fulfills its role in the criminal process, and in particular, whether legislative action should be undertaken in order to introduce statutory changes in the area of the mentioned institution. The most important of the research hypotheses put forward include the following. Number one, crown witnesses, when undertaking cooperation with law enforcement authorities and the justice system, are guided primarily by the motivation directed at the desire to avoid criminal responsibility. Number two, family situation of crown witnesses implies their cooperation with law enforcement authorities. Number three, law enforcement agencies expert pressure on prospective crown witnesses in order for them to cooperate. Number four, the crown witness protection program is functioning satisfactorily and does not require changes in this regard. Number five, law enforcement agencies are not sufficiently engaged on the issue of cooperation with crown witnesses. Number six, crown witnesses manipulate representatives of law enforcement agencies and the judiciary in order to improve their procedural situation. It's my favorite point, of course. And number seven, there is a transfer of credibility of the part of representatives of law enforcement agencies and the judiciary when using the institution of crown witnesses. The expert participating in the survey included, among others, former Minister of Justice, former national prosecutors, judges of the Supreme Court, directors of departments for organized crime, economic crime, and corruption, and heads of organized crime subdivisions, and investigative journalists working on organized crime. In total, expert questionnaires were completed by 11 experts. I will now quote, due to time constraints, some of what I consider to be more important questions and answers, which were the subject of the survey and which I would like to emphasize again, were only a small part of the survey. Question number 1. In your opinion, according, of course, to your professional experience, what are the motives of Crown witnesses when they cooperate with law enforcement and justice authorities? In response to this question, the expert agreed that the main motive for Crown witnesses to cooperate with law enforcement and the judiciary is to, of course, avoid criminal prosecution and, in particular, possibly long prison sentence coupled with financial penalties. Question number 2. In your opinion, does the family situation of Crown witnesses imply their future behavior as suspects and subsequently as Crown witnesses? On question number 2, the expert expressed a convergent view that family circumstances can have both positive and negative effects on the behavior of Crown witnesses. The experts agreed that each situation should be assessed on individual basis. It can happen, for example, that a suspect, after receiving information about, for example, the arrest of pretrial detention of his family, decides to cooperate with law enforcement authorities by expressing his willingness to apply for the status of a Crown witness. Question number 3. In your opinion, do prospective Crown witnesses cooperate with law enforcement authorities before becoming Crown witnesses in order, for example, to eliminate rival criminal groups? In answering the above question, experts generally expressed a consensus view to the extent that certainly the elimination of rival criminal groups is not the predominant motive for Crown witnesses to cooperate with law enforcement and justice authorities, although it may be an additional element in their decision to cooperate with us. In question number 4, in your opinion, according, of course, to your professional experience, do law enforcement authorities put pressure on the prospective Crown witnesses to have to apply for Crown witness status? All experts participating in the questionnaire survey expressed the same opinion that law enforcement authorities put pressure on the Crown witness in order for him or her to be able to use the institution of Crown witness. Question number 5. What do you think about the Crown Witness Protection Program? It's a very important question. Do you have any objection of this subject? In general, the expert responding to the question number 5 on the protection program, and in particular on its possible shortcomings, agreed that it is currently being properly run. Expert number 6 and expert number 9 highlighted cases related unreasonable expectation of the running of the protection program by some Crown witnesses, but true analysis of the expectations put forward by Crown witnesses is not proved. Question number 7. In your opinion, are Crown witnesses manipulating law enforcement and judicial officials for their own personal gain? On the survey question related to the manipulation of law enforcement agencies and the judiciary by Crown witnesses, the experts were anonymous. They anonymously expressed the view that Crown witnesses take actions on the manipulation of the above authorities in order to achieve their particular benefits. Some of the experts were strongly radical in their view of this issue. Question number 8. In your opinion, would it be necessary and positive to subject candidates for and subsequently Crown witness to polygraph and psychological examination as a so-called element of prior, ongoing and follow-up verification? Regarding question 8, the experts were completely skeptical about the use of polygraph and psychological testing. The last but not the least question, in your opinion, does the so-called credibility transfer take place among representatives of law enforcement authorities and the judiciary at different stages of proceedings? The granting of credibility to a crown witness by representatives of law enforcement agencies at the judiciary on the basis that other representatives of the institution have granted such credibility in the course of their proceeding. In response to question number 9, all experts participating in this study expressed an anonymous view that they had encountered the concept of credibility transfer in relation to the institution of crown witness. At the same time, the transfer of credibility was assessed by them in a negative way as a phenomenon that should be eliminated both in the work of law enforcement agency and judiciary. Finally, most experts believe that the institution of crown witness is currently used in moderation, which could not be said about the institution's early days. Perhaps apart from minor adjustments, the expert did not see the need to introduce legislative changes in the field of the institution of crown witness. All respondents agree that evidence from the testimony of a crown witness is extremely difficult and requires careful use, and in particular, the correct and truth verification of his or her initial explanation and the candidate stage and subsequent testimony. An example of moderation in the application of the institution of crown witness may be the data according to which in the first 10 years of the functioning status of institution of crown witness, the status of crown witness was obtained by 90 suspects, and in the last 5 years, only 7 suspects. Thank you for your attention, Mr. Chair. The floor is yours.
This was a very interesting paper. Now I would like to welcome Dr. Erika Varadi-Czema. The topic of her speech is 21st Century Challenges in Juvenile Criminal Procedure. Please welcome.
Thank you. Just a moment. First of all, I would like to introduce myself. My name is Erika Varadi-Czema, and I am a senior researcher of Ferenc Institute, and I am an assistant professor of the University of Miskolc. First of all, I would like to congratulate to organizer to this high-level conference and very interesting subjects. In my presentation, I would like to speak about the 21st century's challenges in connection with juvenile criminal procedure. If we would like to speak about the history of youth justice, we have to speak about the history of social, economic, society, and about the social, economic, or social, psychological changes in the society, and parallel with this, the societies and citizens' changing attitudes towards crime and perpetrators. Why? Because the legal activities or the modifications or codifications activities typically react to the changes of the society. What happened in the 20th and 21st century? We can say that in these 2 centuries was born so significant changes, were born so significant changes which have been never experienced earlier. And the main change was, of course, the internet and IT technologies. So we have to learn so definitions like Internet of Things, the people and machines interaction, and the artificial intelligence. This is things or these processes became so important that we can think about our life without this digitalization nevermore. The second is, or parallel with this, the information society was born. The society 5.0 is a new form of the human coexistence which has so keywords like power, money, and information. And of course, a new risk factors, the so-called e-exclusion in connection with the theory of the famous sociologist Castells. If we would like to speak about young people, other processes were important for us: globalization and the universalization of cultures, customs, music, movies, etc. We can say that the clear winner of these processes is the US culture. Today's child, juveniles, young adult offenders are the member of the Generation Z, which were born between 1995 and 2009. And why is this so important? Because the Generation Z has a significant difference from the generations of the last 400 years. This generation is a digital generation, and the member of this generation live in virtual communities. The digital devices are an integral part of their daily lives. Live as social networking site is very important for them. And what happened parallel with this on the field of the criminal law or criminal procedure? We have a very important date in Hungary in this century. In 98 was born the independent Hungarian criminal code novel in connection with juveniles or children perpetrators, and of course in connection with Hungarian criminal procedural law too. But on international level, this century was the time of recognition and the integration of human rights into the criminal procedure. New forms of diversion, mediation were born. We build the forms of child-friendly justice. In Hungary, we have two very important things or events. One is the ratification of the Convention on the Rights of the Child, because in connection with CRC, we have modified our criminal procedure and criminal legal regulations, acts, and so. The second is the accession to the European Union. So we have a new solutions in criminal proceedings of juvenile, for example, the postponement of indictment, mediation procedure, or preventive patronage. In the 23rd century, a new direction could analyze on the field of international criminal procedure. One is the support for enforcement of juvenile offenders with a migrant background, or the strengthening the access to justice. In Hungary, we have a new criminal procedural act from 2017, and this code has different main objectives. For example, simplification and acceleration of the procedure and the greater protection of the interest of victims, but it hasn't important changes of the field of youth offenders. But we have a very important question. The protection of human rights and of the juveniles' special interest, the require of different treatment, etc. Are really very important thing, and in codes, in recommendations, in conventions, there are several examples to the protection of these rights. But can they work? These recommendations and other regulation can work effectively if they don't pay attention, in the praxis, of course, if they don't pay attention to the change characteristic of the target group. What is so important in connection with Generation Z? They are information and communication technology integrated. So we spoke about the fact that they live their lives on the internet. But it means in the practice that these teens use multiple social platforms, parallel, and not only during the official or other communication, but for example, it is the place of the romance too. So half of teens say they have used Facebook or other social networking sites to express romantic interest to someone. And the social media is very important for us, and not only they, but they and I too, because more than 90% of these teens use mobile to this activity. And the effects or consequences of this situation is, excuse me, excuse me once more, that these young people has a different logical thinking, learning methods, communications, and comprehension competencies, because they were socialized in this digital platform. It means that if we spoke about the different forms of effective engagement, we can say that earlier generation for the earlier generation, the verbal communication was very important. The model person was the teacher, and the main question was the what. So the content was important, and for example, the main sources was curriculum. But for the Generation Z, the visual communication is more important. The model person isn't a teacher, but the facilitator, because the main important question isn't what, so the content, but the how, so the process, because the main sources to learning is the personal experience. This is the one thing. And what is the problem? That they have generational characteristics that make it difficult or sometimes impossible to the exercise of their rights in the proceedings, to the effectiveness of the procedure, or to the achievement of individual prevention goals. So the first problem is, according to the international research, among the member of the Generation Z, the language competencies has very low level or very high degree of lack of language competencies are featured. It means that, for example, 90% in Netherlands or more than 7% in England of juvenile offenders had low verbal communications competencies. And what is the problem? The first is often one word or completely missing answer during the criminal procedure. The second, the consequences among the judge or acting authorities was born the appearance of avoiding responsibility or refusing to cooperate. And
excuse me.
Pardon?
Time is running out, so please conclusion.
Conclusion, yes.
Thank you so much.
No problem. The conclusion is that we have changed our regulation, and it's very important that we use the new technologies, and we have to try to find the 21st century answers to the 21st century problems. Okay, thank you for your attention.
Thank you so much for your speech. Ladies and gentlemen, we have some time before the beginning the last panel, so I think we can take a break. See you again after 5 minutes.